Welcome everyone to tonight's meeting of the Urban Planning Delegated Committee. Before commencing the meeting, I request that all mobile telephones be turned off or switched to silent. Thanks very much. My name is Councillor Westgold and I chair this committee. I will start by introducing my fellow councillors. Seated on this side of the horseshoe table is Councillor Jim Park, Councillor Felicity Sinfield, our Deputy Mayor, Councillor Nick Stavro, Councillor Lisa Hollingsworth, our Mayor, and Councillor Di Gillies. On the other side of the horseshoe table is Councillor Cynthia Watson, Councillor Gary Thompson, Councillor Jane Addis, Councillor Susan Bigger, and Councillor Victor Franco. I acknowledge Manager Governance and Legal, Mr. Brian Wee, on my left, and Director Urban Living, Scott Walker, on my right. There are other officers in the chamber tonight, but they will be introduced as they come forward. As a general introduction, the Urban Planning Delegated Committee meeting is being live streamed on the Council's YouTube to enable public viewing of the proceedings. The meeting is also being recorded and will be made available again on the Council's YouTube as soon as practicable after the meeting. The primary purpose of the Urban Planning Delegated Committee is to deal with issues under the Planning and Environment Act and the Building Act. This committee has delegated authority to make decisions on behalf of Council. For those of you who are presenting this evening, when it comes to the agenda item, it will be introduced first by an officer. Then I will call you to come forward one at a time and join us at the table. If you are making a submission, please present your viewpoints clearly and concisely on why you support or oppose the planning application. Please do not repeat what earlier speakers have said and keep the submission focused on relevant issues and points not previously raised. If you are opposed to the planning application, please tell the committee why you disagree and suggest an alternative approach that would satisfy your concerns. Please focus on your concerns rather than matters of history or detailed in the officer's report. There is a strict limit of 3 minutes for each speaker, including councillors, and whilst as chair, I can vary this time, I seldom do. At the 2.5 minute mark, I will ring a bell to indicate you have 30 seconds left to complete your presentation. For those in the gallery this evening, I would like to take this opportunity to remind you to extend due courtesy and respect to each other and to the committee as a whole, and refrain from inappropriate behaviour. This includes remaining quiet while others are addressing the meeting and not disrupting the decision-making process of the committee. You may only address council with the consent of the chair and must take direction from the chairperson whenever called to do so. Where members of the community disrupt or fail to comply with these directions, that we may have you removed from the chamber. And just to finish, I would like to encourage all submitters and officers and councillors to speak directly into the microphone. This will ensure that everyone can clearly hear the discussion. I will now move to apologies. Mr. Wee, are there any apologies this evening?
Through you, Chair, there are no apologies this evening.
I will now move to minutes to endorse. There are no minutes to endorse, is that correct? Thank you. Declarations of conflicts of interest of any councillor or council officer. Councillors, are there any matters of conflict of interest tonight? None, thank you. I will then move into the body of the meeting. Item 3.1, Planning Scheme Anomalies, Privately Owned Land, Outcomes of Preliminary Consultation. Tonight, the officer's report will be given by Rachel Bryan, Strategic Planner.
Thank you, and through you, Chair. Good evening, councillors, officers and attendees. The purpose of this report is to inform the Urban Planning Delegated Committee of the outcomes of the preliminary consultation process and officer response for a proposed planning scheme amendment which seeks to correct planning scheme anomalies for privately owned land. The report also seeks a resolution to commence the planning scheme amendment to amend the planning scheme anomalies identified. Planning schemes are regularly reviewed to identify anomalies. Burundara's previous review was completed in 2016-2017. Officers have undertaken another review in 2023 and 2024, and 38 properties with some form of planning scheme anomaly have been identified. These are set out in the property data sheets at attachment 1 and mainly include minor zoning and overlay corrections and fix-ups. Preliminary consultation on the various anomalies was carried out from 14th of May to 11th of June this year. Council received 7 submissions in total, comprising 2 supporting submissions and 4 objecting submissions. The feedback relates to 5 of the 38 subject sites proposed for correction. The key issues raised in the feedback are enclosed in the report, and upon review, Council determined the anomaly at 188 to 198 Riversdale Road, Hawthorn, not be progressed with the zoning change. Further investigation has determined that the land is subdivided, which negates the need for the zoning change. This was not reflected in the Vic Plan mapping system, so this is why it wasn't identified until we purchased a copy of the title. Officers recommend the UPDC note the proposed corrections to the Burundara planning scheme contained at attachments 1 and 2 and resolve to seek authorisation from the Minister for Planning to prepare and exhibit a planning scheme amendment to have the zones and overlay mapping anomalies corrected for consistency and accuracy. Thank you, Mr. Chair.
Thanks very much. Now, tonight we have one member of the community with us who wishes to make a submission. It's against the proposal. When I called your name, if you'd come forward and join us at the table. I remind you there is a strict 3-minute limit for the presentation, and I'd ask you to commence your submission with your name and the suburb in which you live. I call upon Liz Burton to join us at the table.
Good evening, councillors and officers. Thank you for the opportunity to speak. I am not in favour of the recommendations, although I do recognise that this is by no means an unusual endeavour.
Can I get you to mention the suburb in which you live, please?
Camberwell.
Thank you.
So this is not an unusual endeavour. However, I think we need to take into account other stakeholders apart from the individual landowners and look at the benefits that we are going to alter. At the moment, the state government has allocated 67,000 housing units for Burundara to develop by 2051 and a significant population increase. So even though on private land, these are small wedges of PPRZ, they have got the benefit that they cannot develop on those parcels. So although you may be determined tonight to rezone them, I think if you look into the future from a more strategic perspective, that there are benefits if you were to realign future developments such as the housing increase and the population increase to look at how many square metres in total are we going to rezone. We don't know because that information is not available, but it does look like a significant amount and it all adds up, particularly in the context of pressures on population increases and housing increases. So what I'm recommending is that there be a strategic review so that this type of activity is not automated but does align with other strategic objectives such as increasing the number of tree canopies across the municipality, which is another strategy that Council has determined to increase it to 27%. But if you have competing priorities and you don't align them, then your your objectives are not going to be achieved. So that is the purpose of my submission tonight. Thank you.
Thank you very much. Councillors, are there any questions of the Speaker? Councillor Gillies.
Thank you, Chair. Thank you, Ms Burton, for coming and speaking to us tonight. I just wondered if you might expand. You mentioned benefits we may alter, benefits to the broader community, I presume you're referring to, but how do you see those benefits playing out to a greater or lesser degree with what's being proposed?
Thank you. We're looking at rezoning varying areas on privately owned land that currently are zoned as PPRZ, whereas the rest of the land is neighbourhood residential. So when a planning application is received, the officer has to look at the zoning of that land, and at the moment you can't develop readily over PPRZ. So on that individually owned parcel, that needs to stay as open. So that is a community benefit in terms of open space, potentially canopy trees, which with the rezoning changes it to neighbourhood residential, enabling development. And it's a legacy from the past. We have it there. It's going to be rezoned and it will then remove that open space. So the community benefit and any alignment with other strategic objectives the council has in terms of increasing the canopy tree cover in the municipality and those opportunities, they also will go.
Councillor Thompson.
Thank you, Ms Burton, for your presentation. Are you of the opinion that a private property owner can, as of right, develop their own land?
In terms of private property ownership, we are all bound by rules and the planning scheme, government strategies and varying overlays and zones. So although we like to think that we can do what we like, we actually are governed by a vast raft of legislation, policy and regulation. So we are all bound by that as property owners.
So to further follow up that question, if an anomaly stays in place, that anomaly sits within the boundaries of a private property, are you comfortable with a property owner fencing off the PPRZ component so it's not publicly available?
Well, my understanding is, although we haven't been told, that it is fenced off. You know, we don't really have that information, but because it is on private land, I'm assuming that it may be it could be in some cases fenced, in other cases it may not be. Yep. But I don't think we know whether it's fenced or not.
Thank you.
But regardless as to whether it's fenced or not, it's not readily developable.
Thank you.
Sure.
Thank you, Ms Burton. That seems to have exhausted questions. You return to the gallery.
Thank you very much.
There only being one speaker tonight, I'll return to the officers for matters arising.
Thank you, and through you, Chair. And just responding to the speaker's questions, I just want to clarify that we're referring to a small number of quite small mapping anomalies which have been assigned as a public recreation zone. However, that zoning should only be applied to publicly owned land. In regard to the broader questions of the allocation of public space to go with our, I guess, growth pressures, we have an adopted housing strategy recently, and we are currently working on an update to the Burundara open space strategy, which will look at the appropriate provision of open space moving forward for the municipality. Thank you, Chair.
Councillors, are there any questions of the officers, councillors? We do have some. Councillor Addis.
Thanks, Chair. I'm trying to understand what anomaly means, and does it, I guess in simple terms, does it mean that this land is actually
should be zoned residential and somehow it appears as something else. I'm assuming the owners bought their properties including this land that's to be made not anomalous?
Thank you, through you, Chair. Yes, the short answer to the question is yes, it's an anomaly, I guess, is a inconsistency. We don't always know where they come from. It could have been a whole of city mapping translation that occurred. Our understanding is it's always been private land and that the mapping area may have been applied incorrectly in the past at some point.
And just to follow up, I think you said that when you look at the title, it suggests that this would make it consistent with the title. Is that what I understood?
So in terms of the public park and recreation zone, under the Practitioner's Guide to Victoria Planning Schemes, which is issued by the state government, the ministerial direction and content of planning schemes specifies that a planning scheme may only include land in a public zone in the PPRZ. So that's why it's an error to the Burundara planning scheme to have a privately owned land under that zoning. So what this audit of the planning scheme has looked at is anywhere where the zoning and mapping is incorrectly applied and amending it so it's more consistent and appropriate in line with the ministerial direction and the practitioner's guide.
Chair, I might just add, we are not asking you to make a strategic decision about open space this evening, and that's where David Cowan outlined. We've got an open space strategy that we're reviewing. We've got a housing strategy. They are strategic decisions. All that we're asking for you to do this evening is to support corrections to anomalies for land that is incorrectly allocated to a zone or overlay in the wrong way.
Councillor Stavro.
I think my question has been answered by the response that Councillor Adders. I wanted, for the avoidance of any doubt, whether the properties that we're talking about are private properties, but I think you've answered that categorically. They are private properties.
Thank you. Councillor Bigger.
Yes, thanks, Chair. And I'm not intending to flog a dead horse here, but really just to clarify, to make sure that I'm certain and understanding this correctly, that this is not, we're not talking about land that has been effectively sort of taken by the property owner, that they've put a fence up. This is a completely different situation than that. Is that correct?
Through your chair, that's correct. The land has been private for an extended period, and the zoning has been applied incorrectly in the past.
So, if I might, so can I just check, for instance, about 2A Warburton Road, where that's the TRZ one, and I guess I don't understand how, for instance, that property was sold to, because it now holds an aged care facility on that property. So it was just sold with the wrong, there was no need to rezone it before it was sold? Was that a mistake on someone's part?
So the TRZ is a state government zone, so it's likely that they have implemented that zone incorrectly, which does sometimes happen. We've had, they have a process of rezoning above council for their sites, and we've seen this with level crossings. The TRZ is also, TRZ1 is a recent zone that the state government has been applying.
So if they have a level above ours, we're now suggesting we're going to effectively go on top of theirs, and I presume we have the right to do that then.
Yeah, we are the responsible authority of our planning scheme, so they go across the entire state, and our job as council is to make sure our planning scheme specifically is accurate. Given it's a privately owned site, it's not appropriate to have a state government road zone over it. If development does come through, it means that our statutory planners can accurately assess development in the correct zone.
Just one final one, if I might, and slightly different, but just to go back to what Ms. Burton was saying about this, can I clarify whether or not this truly is land that, for instance, couldn't be built on, or that we would apply our tree laws differently, or the canopy approach differently in these zones, the way they are currently zoned, as opposed to what we're suggesting, how we suggest to change them? Meaning, that was a poor.
For yourself, Chair, in terms of our tree protection local law, this will make no difference to our tree protection local law and the way that we apply it on private land.
Thank you, I'm happy with that.
Councillor Sinfield.
Thank you, Chair. I'm without the papers in front of me right now because my computer's decided to die, so bear with me. My question's in relation to 2A Warburton Road in Camberwell, and again, without flogging a dead horse, I just wanted to have assurance that, in fact, that's a privately owned parcel of land, because the zoning change seems to be different to most of the rest in the package.
When we undertook the assessment based on council's data from our mapping system, it was. I can check it again right now if you want.
Follow up, if I may, Chair. The parcel of land that I refer to is currently Transport Zone 1, and it's along the railway line, a curved piece of land. It doesn't present as a residential parcel of land. It presents as a state-owned parcel of land adjacent to the railway line, and
Big track land.
pardon?
Oh, big track.
Big track, yeah. And I suppose I'd just like that assurance that, in fact, it's we're not trying to rezone a parcel of state land.
In council's database, it's privately owned. I will say we've done an assessment of state government-owned sites, council-owned sites, and privately owned sites. We've just run the privately owned sites on their own because they're more straightforward. So this site specifically is privately owned.
And sorry, Chair, a final one, if I may. So the title has been checked as well.
It's been checked in council's system. If you want, I can purchase a copy of title.
It's okay, I trust that the due diligence has been done, and I'll take your word. Thank you.
Thank you. Councillor Gillies.
Thank you, Chair. No further questions, just to flag a motion when you're ready.
Councillor Thompson.
Thanks, Chair. Through you to officers, just so I'm clear as well. Two questions. The one, 2A Warburton Street. Do officers anticipate that the private landowner of that will end up having to pay a windfall gains tax as associated with that now that's been rezoned?
I think there's a... To yourself, Chair, that's something that we might need to get some confirmation on. I understand there is some opportunity for exemptions for these sorts of straightforward minor corrections, but we might need to provide some further advice on that.
The land parcels looks like it's about 5,000 square metres. It's a bit more than minor. My second question was just with regards to the minor ones, so where it's 20 square metres, say PPRZ, to Ms Burton's comment, how do officers treat that if you've got a planning application where the substantial part of that property sits within RZ and there's this minor anomaly sitting there, how do officers treat that minor anomaly if there's an encroachment?
Through yourself, Chair, it will depend on what actually is being proposed and what the existing use of that land is. So there will be different arrangements depending on the circumstances and depending on the type of zone that we're talking about. So there may be existing use rights that pertain to that land where the zone doesn't impact or affect that ongoing use or activity. There may be zones that a use or activity is permitted within, that council has the ability to issue a permit for that use or development that is proposed within that land. So it would depend.
So last question, obviously by us going through this process, it significantly reduces officer time in navigating those challenges.
Through yourself, Chair, absolutely. This is a straightforward tidy up that makes sense and makes operationalisation of the planning scheme more effective.
Councillor Hollingsworth.
Thank you. Probably Ms Bryan, you might be able to assist me here. So with regard to 1175 Toorak Road in Camberwell, in the commercial sector, it has quite a mix of zones applied to it, including overlays, etc., etc. With the NRZ1, I was trying to understand whether or not that would have had a residence applied to it with a commercial precinct, and perhaps that could be the reason for the anomaly with it. And I also then wanted to ask, I assume title boundaries would reflect with this, and I think you've already answered that with Councillor Sinfield, that the title searches have been done, the boundaries have been checked, the parameters are correct, and it's just a matter of then rectifying the anomaly. And the reason I ask in this particular commercial zone is I understand there's been, quite a lot of development in these areas over the years, so perhaps it could be some historical legacy.
For that site specifically, that portion of the site is a car park. So, yeah, there's no dwelling that I'm aware of. It's car parking.
Yeah, no, certainly not now, but I was just wondering if there was a dwelling in the past, but definitely it's a commercial zone, and yeah, I completely support the recommendation. Thank you.
Thanks.
Councillor Watson.
Thank you. Councillor Thompson broached the subject that was on my mind, and that's about windfall gain tax. And my concerns centre on 2A Warburton Road, Camberwell, which is currently used as an aged care facility, and the thought that we don't know the answer to whether a windfall gain tax will apply to somebody who is running an aged care facility and they don't have a lot of money. The idea that they could be landed with a big bill makes me intensely uncomfortable, and as it stands at the moment, I don't think I can support the motion without knowing the answer to the windfall gain tax problem.
Councillor Stavro.
Look, I thought I had an answer, but the subsequent questioning sort of starting to provide a little bit of doubt that I've understood private rights here. If a property, one of the properties that is proposed here, is owned, which I'm assuming it's owned by a particular individual right now or whatever, a company, and then it's resold, whoever owns this property has total rights over it. Is that, would I be correct in saying that? They can fence it off, they can do whatever they wish. Obviously, they need to get permits for building on it, etc. But is that correct? They can dispose of the parcel of land and have got perfect rights to do so.
Through yourself, Chair, that's right. They have control of that land, they own the land, they can dispose of that land, and they can perform particular developments or uses of that land in accordance with any approvals that they have or will obtain or can obtain. Absolutely.
So in fact, these lands or these parcels have been traded as is with that overlay on them. Now, the subsequent question is, are you aware of any situations where an owner owned a piece of land like that and for whatever reason realised that there was such an overlay, have decided to take it to the appropriate authority or a court system where they actually have forced the change because they could prove, I own this land, this overlay is inconsistent, can you unwind it?
Through yourself, Chair, yes, there's been anomalies that have been brought to our attention by landowners in the past, and it may well be that some of these, in fact, were brought to us over the years. They've been brought to our attention, and when we run these planning scheme amendments, it's usually a result of receiving these sorts of requests or having these sorts of anomalies identified, potentially by landowners or by nearby property owners, or because there is an application or proposal put forward for a piece of land. So we collect these over a period of time, and that's why these planning scheme amendments are run on a periodic basis. And perhaps if I just highlight one substantial point where there were a number of these anomalies, and I'm aware of this right across Melbourne, there was a change to all planning zones across all of Victoria, in fact, in the late 90s. I think it was about 1997. And that actually resulted in a number of these anomalies being applied to land that has subsequently been picked up over many, many years across many councils.
If I may, as a final one, and are you aware whether, let's say a council is not as responsive as we are to these requests, whether there's been recourse sought in the court system and whether an owner can be successful doing that?
I'm not aware of any of those sorts of claims at Burundara Council.
Anywhere else?
I'm not aware of any being ultimately tested in the court system. I am aware from previous experience of claims being made, but then corrections subsequently being made to address the issues that were raised by those landowners. So the correction to the planning scheme was the mechanism to provide relief for such a claim.
Thank you.
Before I move forward, I might just check with the officers whether you wanted to comment further, and Councillor Watson's, I presumed it was a comment, but it may not have been. You may wish to speak further on that.
Through yourself, Chair, the advice that we've received is that corrections will be exempt to windfall gains tax. However, that is still open to testing because the windfall gains tax has not been fully tested in all scenarios, and there may be arguments that this is not a correction. Our view is that it clearly is a correction. These are corrections, and we understand they would be exempt from windfall gains tax.
Mr. Storer, do you have a comment?
Thank you, Chair. Perhaps just to put the windfall gains tax question into perspective, if the tax applies and is payable, then by virtue of the fact that it's payable, it means there has been an enhancement to the value of the property. So the owner will pay some tax, if indeed it's applicable. However, in the absence of the rezoning, there will be no increase in value. So if you think about this from the point of view of the impact on the owner, there's going to be some increase in value of the land if they are liable to pay windfall gains tax, and without it, they won't attract that increase in value. So I'm just trying to give you some sense of how the windfall gain tax will actually play out if you are concerned about it. It doesn't erode the value entirely, but if you don't change the zoning in a way that creates the liability to pay it, then they will not attract the value uplift.
Chair, I might just add one more point to what Mr. Storer has indicated as well. The windfall gains tax, if there is any that needs to be paid, does not have to be paid until the property, for 30 years, or until the property transfers, if so chosen by the landowner.
Given, Chair, that we're discussing my question, could I just ask one more follow-up question and ask, has this issue been discussed with, I think, what are they, the Blue Cross, the Muse Aged Care Centre? Are they aware of the potential for change, for windfall gains tax? Like, have we entered into any discussions whatsoever with them?
Through yourself, Chair, we have consulted with the owner about the proposed rezoning. So they are